Mr. Chairman, Ranking Member Feinstein, Senator Hatch, I am very grateful for the opportunity to be here today and to testify. Last month, as you know, 43 of my colleagues and I sent a letter to leaders of Congress regarding the Ensuring Patient Access and Effective Drug Enforcement Act, which I too, Senator Grassley, will just refer to as the Act. The Act has been, we believe, a step backward in our collective efforts to prevent the unlawful distribution and diversion of opioids that have contributed to our national epidemic of drug addiction and death. The DEA is a vital federal partner for all of the attorneys general across the country. It needs a complete set of tools to be effective in this struggle, and in our view, the Act handcuffs the DEA. It makes it more difficult to stop dangerous and illegal shipments of narcotics. The Act also gives additional protection to those suspected of illegal activity. It requires the DEA to evaluate corrective action plans instead of moving swiftly to suspend or revoke the registration of bad actors. The consequences of the epidemic include, as has been noted in part, in 2016, more than 2 million Americans were suffering from addiction to opioids. Since the year 2000, about 200,000 Americans have died from overdoses of prescription opioids, another 100,000 from other illicit drugs like heroin and fentanyl. It keeps getting worse. In this year, in 2017, we're projected to reach 70,000 deaths. That's as many deaths, that's more deaths than Americans killed during the entire Vietnam War, just this year. The epidemic rages on, despite clear evidence that the prescription, distribution, and manufacture of opioids in excess of medical needs is contributing to its severity. The letter from the state attorneys general put it last month in part as follows. The Act effectively strips the DEA of a mission-critical tool, namely the ability to issue an immediate suspension order against a drug manufacturer or distributor whose unlawful conduct poses an imminent danger to public health or safety. Under the Controlled Substances Act, the DEA has authority to issue immediate suspension orders where the DEA finds there is an imminent danger to public health or safety. The Act altered this standard definition by requiring a substantial likelihood of an immediate threat of death, serious bodily harm, or abuse of a controlled substance. And this language has essentially or effectively eviscerated the DEA's ability to act, drawing the standard so narrowly that, in the words of Judge Mulrooney, who has been cited often this morning, it is now, quote, all but logically impossible, end quote, for the DEA to suspend a distributor for failing to comply with the law. The Act also further constrains DEA's effectiveness by giving manufacturers and distributors a new opportunity to avoid sanctions for engaging in unlawful diversion. The new law allows a registrant to file a corrective action plan prior to an appearance for a show cause proceeding. DEA is required to first give the manufacturer or distributor at least 30 days to prepare a corrective action plan, and then to consider that cap in determining whether enforcement proceedings should continue. In effect, it affords lawbreakers leverage to obtain additional chances, and as Judge Mulrooney points out, it is akin to mandating that law enforcement authorities allow shoplifting suspects caught in the act the opportunity to outline how they intend to replace the purloined items on store shelves. I remain mindful of the imperative that in fighting this crisis, we must be careful not to overcorrect. We must not impede patient access to prescription drugs that serve immediate and legitimate medical needs, but my colleagues and I believe that the Act from last year does not advance this important goal. it just diminishes DEA's ability to prevent unlawful opioid diversion. We face, as has been said a number of times already this morning, a public health emergency. The country's success in defeating this threat depends on all of us, state, local, federal authorities working together effectively. We're fighting a public health conflagration of epic proportions, and I believe that last year's act stands on the fire hose. I would urge you to repeal it. Thank you very much.
Start with General Frosh. 43 attorneys general, including yourself, asking a letter asking for repeal of the law. That letter said the language, quote, effectively eviscerates the DEA's ability to act, and you also said that in your testimony. This first question probably doesn't take a long answer. It's the second one I would like to have more, but the first question, do you have any data to support what you're telling us? And if not right now, would you be willing to provide that data?
Sure. Thank you, Mr. Chairman. Yes and no is the answer to do we have data. You've put up data that I think shows how infrequently ISOs are used. Okay. And with all respect, I think some of the comments are looking at it from the wrong end of the telescope. You see how few there are. I mean, even before the act, you saw that there are in the single digits for, I think it was 2011, perhaps there were 65 and dropped precipitously down to 8, 5, 9, et cetera. And what that shows you is that the ISO is used extremely infrequently. So to pass a law that makes it more difficult to use one when the actual numbers are in the low single digits doesn't really make sense. I think you have a 40-year history of the language that existed in the statute before last year's act.
Maybe you could give us some examples in your state of where the law has negatively impacted your investigation.
We work closely with DEA. We just did a major case with them 2 weeks ago. We have busted pill mills and doctors who are selling prescriptions out of their cars. We don't have the authority to stop distribution. All we can do is catch it on the back end. And so it hasn't impeded our office, but it's pretty clear, I think, from the article written by Judge Mulrooney and by the paucity of cases that are brought, that the law is at best unnecessary and at worst harmful.
Okay. Mr. Gray, my first question may appear to be confrontational, but not my second and third one. Okay. In advocating for change, wasn't the industry trying to weaken DEA's enforcement authority so that your companies wouldn't be shut down in the face of ISOs?
Get used to this button. That was not my take at the time all this happened. I lived through the process of the communication shutdown with DEA when they changed hands in 2006, and I witnessed listening to our members and the groups that we put together to talk about this struggle mightily with determining various standards and algorithms for determining what is a special order, a special suspicious order, and what isn't. This went on for a number of years. Enforcement began happening. In one case, as I indicated in testimony, the problem had already been fixed, and yet the enforcement was done. And the bottom line is, it appeared, and the reality is in the minds of the people dealing with it, it appeared to our members that the goal line was constantly being shifted. And there was no steady state by which a company would look at an order and say, yeah, this is absolutely suspicious, I should report it. In fact, I can tell you anecdotally, I know one company that met with a field office.
Instead of an example, I think you just answered my second question.
Okay.
Why wasn't the previous language sufficient to provide the companies clear guidance on how to operate effectively and lawfully?
Well, the guidance was merely 2 letters, 2-page-and-a-half letters that called for the reporting of suspicious orders. There was no definitional work behind it. We then began asking, can you do some regulations around this so we have an idea of what some of these terms in this letter mean for reporting these orders. We submitted over 40 questions 3 times to the agency, never got an answer. So the bottom line is, in this period, the wholesale distributors were on their own, developing their own algorithmic systems to determine it. Some of my members had to do it by hand. Some had the resources to invest in computers and make it, more effective and quick. But the bottom line is, they did this in the blind. And the consequence was, at a time that when this opiate problem was beginning to expand, as Ms. Chambers noticed, availability of these drugs became limited because our members, the old adage, when in doubt, cut it out. When the DEA would not answer, yeah, that is or isn't a suspicious order, they would just cut off the pharmacies. And
Okay, this is my last question. Can't the distributors work effectively with the DEA without limiting DEA's authority to make sure opioids don't fall into the wrong hands?
Well, we try to make that in our daily delivery, how the process moves. We try to make sure that only gets to licensed DEA pharmacies. We don't ship to anything that doesn't have a DEA license. I don't know if that answers your question, but that's the process.
Well, let me state it again. I don't think it does. Can't the distributors work effectively with the DEA without limiting DEA's authority to make sure opioids don't fall into the wrong?
Absolutely. And I think we can. And I think we have. And I will tell you this, since the change at DEA, there's 2 DEAs, the DEA between 2006 and 2016 and the DEA today. I think our members would agree the working relationship has been dramatically improved. Is it because of this law or the change? I don't know. But there is definitely a more open communication line. I've had my own personal conversations. We've had our own meetings. There is clarity. I will tell you as an example, DEA put on a wonderful meeting a year ago, and a young gentleman on their legal team came in and discussed the Masters case. You may or may not know the details of that. It's not important, but what he did is he outlined for all the registrants, pharmacists, everybody in the room, and said, look, here is this case. This is what we're expecting on the appeal. If this happens, this is how DEA can use this case to enforce. That helped our members immensely to understand where the lines were being drawn. So, and that all happened within the last 24 months. So it has improved, and we're going to continue to work with them.
Senator Feinstein.
Thanks, Mr. Chairman. I'm from a medical family. My father was a general surgeon, and my husband, who passed away, a neurosurgeon. So I'm very well familiar with the term do no harm. In my view, this bill has done harm. And I look at these figures, and I look at the answers that we got from the DEA, and it seems to me that we should look very closely at repeal. My question, General, is how do you view the possibility that this could really be turned into something that could be workable? There is so much money to be made and so much that has been made that it's very hard for me to see any amendments turning this around.
Thank you, Senator. I am not able to tell you what could be done to fix this. The position that I've taken, the one that my colleagues, the 43 other attorneys general, have taken, is that it ought to be repealed. We think it does. We think it does do harm. I think opioids are overprescribed and and taken too often in the United States. We're 4% of the world's population. We consume 30% of the opiates, prescription opiates. And we experience 27% of the overdose deaths in the world. That's an extraordinary relationship. I mean, we're punching 8.5 times above our weight in terms of consumption and death. As everyone has noted, 14 billion pills per year for our country. It's way, way too many. And we have, of course, to strike a balance. We want to make sure that people who are suffering horrible pain get the relief they need. but we're so far in the other direction that we need not just a course correction. I mean, I believe that last year's act went in the wrong direction. Taking us back to where we were before is at least a step forward.
Thank you. Mr. Calzone, how, if the bill were repealed, what would the Board of Pharmacy do? What actions would you take, most likely?
Senator, if the bill was repealed, I think the states would continue to utilize the resources they have and probably provide more cases over to the DEA that they've investigated and found. And perhaps if I can comment just a little bit further.
Please. Go ahead.
There's either something wrong with the data or because simply the facts don't match. So if we have a situation where the committee and DEA are reporting that the issuance of ISOs were minimum against wholesale distributors, or none since 2012, 4 years prior to the enactment of the law, but the industry is saying that it was a device that was threatening or stopping shipments, something is not correct there. Either ISOs were being issued or not, either the industry was being affected or not impacted by it. And then the other question Senator Kennedy asked, if you ship 9 million dosage units to one pharmacy, where are the safeguards if the DEA is not able to stop that? What's the responsibility on the wholesale distributor in those cases? And that's where we think the law would need to be amended.
Well, I'm looking at this chart of ISO suspension orders from 08 to 17. And in 2011, there were 65. And I asked the question, why? And it was the pill mills. And then it began to drift down. In 2014, it drifted down to single digits. And it's remained in single digits. So this, in view of what we know is out there, indicates to me that the agency isn't properly functioning because the suspension order should be way up. And I don't know whether there's interference. I know there's money to be made, interference from the pharmacy industry or anyone else. But it appears to me, based on these figures, that the law is not working. Do you agree with that, or do you find otherwise?
We agree the laws are not working.
Mr. Frosh?
Absolutely, they're not working, Senator. We have so many, 200,000 deaths since 2000, the year 2000. 2 million people in our country addicted to opioids. They're clearly not working.
Mr. Gray?
Well, as far as the laws, really since 2012, 2013, that was the high watermark for the West Virginia situation as a good example. And that was a systemic failure from overprescribing. You know, we live as a logistics group, we live in a pull system. It is pulled by the prescriber, filled by the pharmacist, and then the pharmacist orders to the wholesaler. And the wholesaler only ships to DEA licensed groups. So and all the way down to the manufacturer, there was a systemic failure of reporting. Our members, based on the lawsuits in West Virginia, did file the suspicious reports. They filed all this data with DEA, and yet there was no enforcement action. Now, at the same time, I know for a fact that our companies were working overtime on these IT systems to determine suspicious orders. And what I would argue, what's happened since 2012 and 2013, because I've heard it quiet down. The phone calls to me have quieted down. There's less and less confrontation between DEA agents, I believe, and my members, because I think my members are doing the better job now that they've self-defined for each company.
You really believe that?
Yeah, today.
With all of the pills that are out there, your members don't realize this is too many?
No, again, the DEA sets that quota. The product comes in, but we only ship on, so if every 50 states in the union orders this product, it's mathematically, yeah, it's high, but we ship. And we are reporting our suspicious orders. And so there haven't been enforcement actions, and there's been meetings about issues, but it's not been followed on. I think, I think as far as my 35 companies, it's trending in the right direction to get this correct.
My time is up. Thank you very much.
Thank you.
Thank you.
Senator Hatch.
Well, thank you, Mr. Chairman and Madam Co-Chairman. I'd like to begin by thanking our witnesses for appearing here today. In particular, I'd like to thank Ms. Chambers, who is a constituent of mine, and I appreciate her coming. I think you've played an important role in bringing this issue to my attention. And you've shown a lot of courage by being here today. I really appreciate it. Let me just ask Mr. Frosh, I'd like to ask about the letter you and a number of other state attorneys general signed calling for repeal of the bill. I found the letter curious because in making the case for repeal, the letter essentially relies exclusively on Judge Mulroney's article. It cites no data or indeed anything other than Judge Mulroney's article in describing the law's impact. So my question is this: what independent analysis of the law did you and your colleagues conduct before deciding to send the letter? Evidently, you read Judge Mulroney's article. Did you do anything else?
Yes, Senator. First, let me say I found Judge Mulroney's article to be very powerful and persuasive, but there is no data since the law was passed, so we don't have that to work with.
Yeah.
But each one of us, all 44 of us are attorneys, and we looked at the law. And I know when you try to prove a case, when a standard changes, it's significant. And the change here is an extraordinarily high standard. When you have to prove a substantial likelihood of an immediate threat of death, serious bodily harm, or abuse of a controlled substance, it's extraordinarily difficult. And that is a very, very high standard.
Sure.
And any lawyer can tell you it makes a big difference. So there's no statistical analysis that I can give you, but there is a legal analysis, and it's shared by 43 other AGs, and we're evenly divided among Republicans and Democrats.
Okay, Mr. Gray, the 215 GAO report I referenced earlier described how an absence of clear guidance from DEA to distributors regarding what constitutes a suspicious order
Correct.
and what can trigger an enforcement action was leading some distributors to decline to fill orders even when they had no evidence that a pharmacy or doctor was engaging in diversion. Can you explain to the committee how the absence of clear guidance was impacting distributors' practices and how the Ensuring Patient Access Act addressed that particular problem?
I can, and I think I just want to lead off by saying, and following up with Senator Feinstein, I think the key to this law is, like any other law, we need to give it time and to find out if there are issues or concerns. After 18 months, this law has not been really tested in the marketplace, and I think time will tell, and if it's appropriate, then we will go back and amend if you have to. But as far as the process it unfolded, right, I mean, our members struggled between 2007 and 2012, 2013 by numerous attempts to have meetings. I went to one of them. Mr. Ranazizi didn't attend that meeting, and that happened to be the last meeting in 2010, and we never met again with DEA. We submitted written questions, very specific questions about suspicious orders, the nature of suspicious orders, things, getting into the location of pharmacies, where are they near pain clinics, are they near state borders, and what have you. And we've submitted those questions 3 times. We still don't have any feedback from them. So our members, as I said, they went on, they had to go on their own initiative to try to define those lines. Now, you indicated they stopped supplying with no evidence. I can't speak to an individual company's decisions, but I do know many of them I spoke with would call me after their DEA meetings, quite honestly terrified, saying, look, I think they're going to pull my license. We're not sure if this stuff's suspicious. It's on the edge. Because the other problem is, when our members submit to one pharmacy a shipment of pills, we report that order, whether it's suspicious or not, to the DEA on a weekly basis. So the DEA has that. But what's not told is the DEA also has data regarding multiple other distributors, because many pharmacies are served by more than one wholesale distributor. And so and the DEA has all this so-called ARCOS data. I have asked the DEA for years Can the DEA look at us as partners in this and try to share some blinded DEA data, our full data, so you can see the full picture of a pharmacy? So my wholesaler can look at it and say, all right, well, my shipment is kind of on the edge, but if there's 3 other wholesalers also submitting, well, then it's clearly in the realm of suspicious, and we should cut them off. I have been, I've asked, well, I believe about 3 times formally, can we do this? Can we get together? And I keep getting answers that, we can't blind the data and this and that and the other. I never have quite believed the legal argument they like to use, but that's fine. But I sure wish Arcos data is a powerful tool here and is something that hasn't come up in this hearing. But Arcos data sharing with the wholesale distributor would help clear a lot of this problem up. I've said it for years. If the DEA sat down with my 35 members and constructively used Arcos data, I would believe within 24 months, most of the bad players in this country could be ferreted out very, very quickly, as opposed to the gotcha game we've been playing.
I'm glad to have your testimony. We've heard a lot recently from former DEA officials expressing concerns about the Ensuring Patient Access Act and other aspects of DEA's interactions with registrants. From your perspective, has communication with DEA improved in the last 18 months since the Ensuring Patient Access Act became law?
Well, it absolutely has. With a change of personnel, I was able to open a line of communications with the head of the diversion control. We had several conversations personally at some of our meetings. The DEA has been available for our conferences. They come and speak directly to our members. And instead of bringing the old slideshow, which they showed 10 years in a row, we now have new information they're sharing with us, which I think is a huge improvement. And moreover, as I indicated earlier, and Demetra mentioned it, they'll have another stakeholder meeting this spring. We had one a year and a half ago when that young attorney from their office came in to give his musings on the Masters case and what it would mean if the DEA won that case. Well, the DEA won the case, which is great, but now my members at least have an idea what DEA is thinking in terms of where the next legal boundary is. So I think it's 100% improved in the last 18 months. I can be very complimentary of the DEA since then. It was not the case from 2006 to 2016.
Well, thank you so much.
Thank
Appreciate
you.
it. Thanks, Mr. Chairman.
Thank you, Mr. Chairman. I'd like to ask the committee, and I'd like to, on behalf of all of us on the committee, thank those of you on the panel who've testified today. The ongoing opioid addiction crisis is something that has harmed every single community, has affected every state. Just my small state of Delaware lost more than 300 people who died in drug overdoses last year. And what we're trying to do is to strike the right balance between making sure that people who suffer from persistent and chronic pain, like Ms. Chambers, can get access to appropriately prescribed and managed opioids, and those who are abusing them or misusing them are appropriately held to account. And so striking that balance is the purpose of our hearing here today, and I'd appreciate a few pointed answers to some simple, hopefully pointed questions. To Attorney General Frosh. Delaware, under the leadership of our Attorney General, Matt Denn, recently enacted new regulations that allow prescribers to better monitor each opioid prescription and that limits an adult from receiving a first-time prescription for more than 7 days, except under exceptional circumstances. And that's led to a 12% decrease in the number of opioid prescriptions just since April 1. Shouldn't we be looking at some of the positive, innovative work that's being done in states like Delaware?
Yes, absolutely. A number of states have prescription drug monitoring programs. They can be extraordinarily effective, despite the fact that laws like that have been enacted in Delaware and across the country. We still have this tidal wave of opioids washing across, and those are important steps forward, but we have a lot of work that remains to be done.
So help me, Attorney General Frosh, Dr. Katzion, if you would. The DEA's use of immediate suspension orders has dropped, but other enforcement tools like orders to show cause have increased. Are these other tools sufficient to combat the misuse or misprescription of opioids?
I don't think they are. I mean, and you only have to look at the results to come to that conclusion. DEA has essentially had the same tools for 4 decades, and they have not been sufficient to overcome the wave of opioids that has washed across the country. So I would say not. Now, you know, the prescription that I would give is holistic. We not only need effective law enforcement, interdiction of illegal supply, but we also need treatment. We need prescription drug monitoring. We don't have nearly enough treatment beds in our country, and you know, we're not making forward progress, or we're making progress, but it's incremental. It needs to be much more rapid.
I agree with you. Dr. Ketzion, what else do you think DEA should do, or what else can we do as a committee and a society to address the significant problem of opioid addiction?
I think the answer is the balance that you spoke about. We need to have a balance between access but effective law enforcement. And to the prior question, we haven't had time to analyze the data the committee presented today, but if you look at the data an overview, the DEA's taken actions in other areas to compensate for the inability or their concern about trying to take an ISO. So there has to be some balance there as well. ISOs should be restricted to the most serious, egregious cases where patients are going to be killed if that pharmacy, that distributor, that doctor continues to operate. In those cases, the standard worked. You saw by the data the amount of times the ISOs were used were very limited. So we think restoring or eliminating that data, that new standard, is a means that would quickly address the issue and give the DA that important tool back to use that in very limited but very serious situations.
Mr. Gray, you represent distributors. There's been a lot of concerns expressed today on both sides about the Ensuring Patient Access and Effective Drug Enforcement Act. How do you think we can fix it? And how do you think we can improve and sustain that working relationship that you just talked about with the DEA to crack down on inappropriate overprescribing behavior, and to make sure that those who are genuinely in pain, like Ms. Chambers, are able to access the prescription opioids they need?
First, let me say that the DEA, I think, does agree with us. There needs to be some definition of imminent danger. If it's not the right one in the law, then we should fix it. But as I said, let time see how that works out. And it may a rush to judgment. I agree with someone on the panel alluded to, is probably not the best way to go, the most judicious way to do legislation. But that being said, I personally believe we can talk about the mechanics of law enforcement and pain management, but from a personal experience, and this just happened to me in the last 96 hours, I spent 24 hours in a major hospital here to have this shoulder bone. I now understand pain. I never understood persistent pain. Since August 3rd, I have had pain every day in my body, move in different places, from my shoulder down through my arms, and it has been miserable. 2 surgeries, the most recent last Thursday, to fix this bone for the second time, and then scope out this shoulder. And in the hospital, in that 24-hour period, I was asked no less than 5 times this question as I sat down wherever I was going in. Could you describe your level of pain? And I looked at these people and I said, this isn't about the pain. Pain will take care of itself. Well, you need to give me a number. What's your pain? So I began making up numbers. And then when they sent me out of the hospital after 24 hours with a prescription of oxycodone, we couldn't get it filled. My insurer wouldn't pay for it. And so it's like, well, so I paid for it, and I used about 5 of them, and that's it. And I'm off it now because it's not good stuff. But it did immediately after surgery. But it's a systemic problem beginning with the medical community, if you ask me. I'm not picking on them, but the bottom line is there has become a pattern in the medical community that pain management makes healing go faster.
Mr. Gray, let me just re-ask my last question, if I might. You concluded with what seemed an intriguing possibility, that distributors and the DEA could work more closely together to genuinely identify bad actors and to allow the continued delivery of needed pain medication to those who legitimately need it.
I have firmly held, if the DEA, opened the door and said, let's work with you as a registrant, not as a criminal, as we used to be defined by someone in that agency. We were called criminals. If we worked as a registrant, I actually believe between the resources and the access of information that my members have, and then the bigger picture information DEA has, this shouldn't be a problem to identify the bad players, in my opinion.
I appreciate your testimony, but, you know, as you represent
Yeah.
those who struggle with pain
Right.
chronically and daily, those who are charged with law enforcement and protecting our constituents, hundreds of whom are dying, thousands across the country, and those who are pharmacists professionally trained to dispense appropriately and distributors, we have to get this right. We have to work it out, and we need a sense of urgency about it.
I agree.
Because there are literally people dying and people suffering needlessly. Thank you,
right.
Mr. Chairman.
Senator Hatch had one other thing he wanted to do.
No, I just want to thank you all for being here.